Today we are going to discuss about the constitutional bodies. Constitutional body means that we have discussed in the previous class on the non-constitutional bodies. All the government bodies, we can divide them into either constitutional body or non-constitutional body. Then one body we can make it as constitutional body and second one is non-constitutional body. The meaning difference is that if any government body or a government organization is mentioned in any article of the Indian Constitution, and that is called as the constitutional body, that is a body established by the Constitution of India. And if it is not mentioned, if a government organization is not mentioned in any part of the Constitution, then it is called as the non-constitutional body. Then we are going to discuss, and our discussion was on the constitutional bodies. Then today's discussion is on Election Commission of India. Then Election Commission of India is a constitutional body. Then we have to see if it is a constitutional body, it would be discussed somewhere inside the Constitution of India. Article 324 of the Indian Constitution. Article 324 of the Indian Constitution establishes a constitutional body named as Election Commission of India. Then Election Commission of India, what are their duties, what functions they are doing? All of us know when there is an election in the country, Election Commission of India comes forward and manages the complete election in the country. Then Article 324 of the Indian Constitution discusses about a constitutional body named as Election Commission of India. Then this Election Commission of India, we can see what elections they are managing. One is election to the office of President of India. Then election of President of India will be managed by Election Commission of India. Second one is election of Vice President of India will also be managed by the Election Commission of India. Election of Lok Sabha and Rajya Sabha will also be managed. Election of any state legislative assembly or any state legislative council is also managed by the Election Commission of India. Then even there is another body named as Election Commission of the State. We have already discussed that in the chapter on the Panchayati Raj institutions. That Election Commission of the State, they are not the body who are looking after the election of state legislative assembly or state legislative council. Election Commission of any state government, they will look after the election into panchayats and municipalities. Then that is they don't have any power in the election system of the state government or election system of the state legislative assembly or the state legislative council. That is also managed by Election Commission of India, which is established under Article 324 of the Indian Constitution. Then again, Article 324 talks about who is the authority, who is the appointing authority of the Election Commission of India. Then Chief Election Commissioner of India and the other commissioners, other election commissioners are appointed by President of India. Then President of India is the authority of appointing the Chief Election Commissioner of India and the election commissioners of India. Now, next discussion is that how many election commissioners would be there in India? What are the total number of election commissioners in India? Constitution tells that Constitution explains that the number of election commissioners in India also fixed by President of India from time to time. The number of election commissioners, that is also fixed by President of India from time to time, because according to the increase in the population, when the population of the country increases, along with that the election machinery also needs large management. Then according to the increase in the number number of population, there should be a parallel increase in the number of election commissioners of India. Then the constitution speaks that from time to time President of India will fix how many number of election commissioners would be there in India. At present, all of you know there is one chief election commissioner of India plus 2 election commissioners in India. Then this is the present system. There is one chief election commissioner of India and 2 election commissioners. Then election commission of India, at present it is a body of total 3 members, then 1 chief election commissioner plus 2 commissioners. And this system of having 3 members started from 1993. Then starting from 1993, we have a 3-member committee named as Election Commission of India. Before 1993, for most of the period, it was a single member body under 1 chief election commissioner of India. Then at present, we have 3 members, but constitution tells that it will be decided by the President of India how many number of members would be there in the Election Commission of India. And the speciality is there. Although there are 3 members, all these 3 members have equal power and equal salary. It is not like this, because Chief Election Commissioner of India, he is the head of Indian Election Commission. Because he is a head, he does not have any extra privilege or power. As he is the chairman, when the meeting of the 3 happens, when the meeting of the Election Commission of India happens, the chairman has only one extra power, that he will be the presiding officer of the meeting of Election Commission of India. Other than this, there is no special power. Then there is all the three members, including the Chief Election Commission, they have equal power and equal salary. Their salary is also equal and the powers are also equal. There is no special power for the Chief Election Commissioner of India other than presiding over the meetings of Election Commission of India. Now imagine that one decision has to be taken. If a decision has to be taken, then it will be taken. Imagine one decision, 2 members, these 2 members are supporting one decision, and this one Chief Election Commission of India, they are opposing that decision, and 2 members are supporting that decision. Then decision will be taken as per the majority opinion. There is no special value for the opinion of the Chief Election Commissioner. Even if the Chief Election Commissioner is opposing one decision and the other 2 members together are supporting that decision, then the decision of the 2 will be implemented. The decision of Chief, because he is the minority here. Then in the Election Commission of India meetings, decisions of the commissions are taken by the majority members' opinion, not by the opinion of the Chief Election Commissioner of India. Then majority is the important in the meetings of Election Commission of India. All members have the equal power in the Election Commission of India. Next discussion is that how much is the term of Chief Election Commissioner and the Election Commissioners of India. Once appointed, how long they will continue, what is the term of Chief Election Commissioner and the Election Commissioners. That is either 6 years after being appointed or 65 years of age. Then if a person is appointed when he is 50, he will continue for 6 years, that is 56 years of age. Then if the person is appointed when he is 50, then that person can continue for 6 years. Imagine that another person is appointed when he is 63 years of age, then he will get only 2 years of the service as the Election Commissioner of India and the Election Commissioners of India, as the Chief Election Commissioner and the Election Commissioners. For both of them, the term is either 6 years or 65 years of age, whichever comes earlier. If 6 years finishes earlier, then they will retire after 6 years of service, and if the 65 years of age comes first, they will retire at the age of 65. Now next discussion is that how is the removal of the Election Commission of India. Then how a person who is appointed as the Chief chief election commissioner or the election commissioners, how they will be removed. The removal of the CEC, Chief Election Commissioner, and the election commissioners is similar to the removal of Judge of Supreme Court. How a Judge of Supreme Court will be removed? In the same manner, the removal of the election commissioner, Chief Election Commissioner, and the election commissioners would be done. How is the removal of the Judge of Supreme Court? That we have discussed earlier. Removal of the Judge of Supreme Court is a big procedure. It's one of the toughest removal procedure in India. That is, for removal, the removal motion has to be introduced. If it is introduced in Lok Sabha, it has to be introduced by 100 members of Lok Sabha. If it is introduced in Rajya Sabha, it has to be introduced by 50 members of Rajya Sabha. After being introduced either in Lok Sabha or Rajya Sabha with the support of this much members, that is 100 in Lok Sabha and 50 in Rajya Sabha, the presiding officer, that is the Speaker of Lok Sabha or the chairperson of Rajya Sabha, then presiding officer has to admit the motion. If the motion is admitted by the presiding officer will make an inquiry committee. Then the next procedure is the inquiry committee. Then after that, one inquiry committee would be formed by the presiding officer. It is a 3-member committee. We have discussed who are the 3 members. The first member in the committee is Chief Justice of India. Second member in the committee is the Chief Justice of any High Court in India. Third member in the committee is an eminent jurist and who is an expert in judiciary. These 3-member committee, they will make an inquiry. If the inquiry committee finds the alleged offense is true, that the proved misbehavior or incapacity, these two are the 2 reasons for removing the Judge of the Supreme Court. The same is the removal of the Chief Election Commissioner and Election Commissioners of India. If they find the person guilty of the offense, they will submit the report to the concerned house which has constituted the committee, and then Lok Sabha has to pass it with special majority, and again Rajya Sabha also has to pass it with special majority. Then both the houses, Lok Sabha and Rajya Sabha, have to pass it with special majority. What is special majority? We have discussed. That is the majority of 2/3 of the members who are present and voting, that is not less than half of the total membership of the house. Then this is the removal of the Chief Election Commissioner of India and Election Commissioners of India. Constitution describes that their removal is equal to the removal of the Judge of Supreme Court of India. How is the removal of the Judge of Supreme Court? That we have discussed. This much procedure has to be followed in the removal of both Judges of the Supreme Court and the removal of the Chief Election Commission of India and the Election Commissioners of India. Then the majority needed for the removal in the parliament is the special majority. Then they can be removed only with the special majority. One more condition is there. While the removal of a person who is a member of election commission, we have already discussed that election commission is one chief election commissioner of India plus 2 commissioners, 2 election commissioners. Then while the removal of these 2 election commissioners, if the removal is for anyone from the 2 election commissioners, then for that removal, for introducing that removal procedure, the recommendation of the Election Commission of India is mandatory. This is a provision to protect these 2 election commissioners. That is, they cannot be simply removed. For removing them, the authority to file a complaint that they have done the misbehavior or they have some incapacity, the authority to file the complaint is only Chief Election Commission of India. Then for protecting the members, Chief Election Commissioner has some power that for their removal the recommendation has to start from them. That is not there in the case of Chief Judges of the Supreme Court of India. Judges of the Supreme Court, the removal procedure can simply start in any house, whether it is Lok Sabha or Rajya Sabha. But in the case of removal of the election commissioners, first the complaint or the recommendation should go from Chief Election Commissioner into either Lok Sabha or into Rajya Sabha. Only then they can start the motion for the removal of the election commissioners. That protection is not there for chief also. Only for the two election commissioners, for their removal, the recommendation should go from the Chief Election Commissioner of India. Next constitutional body is Union Public Service Commission, otherwise simply we are calling as UPSC, Union Public Service Commission. And this is one of the most important body for the civil service aspirants, because many civil service aspirants are appearing for the UPSC civil services examination. That includes the IAS, IPS, etc., IFS, Indian Foreign Service, Indian Administrative Service and Indian Police Service. Then Union Public Service Commission or UPSC is also a constitutional body and a complete part of the Indian Constitution. That is Article 315, and from Article 315 to 323 of the Indian Constitution discusses about the Union Public Service Commission. Then UPSC is discussed, different provisions related to UPSC is discussed from the articles starting from 315 to 323 of the Indian Constitution. UPSC will have one chairman. The composition, first we are going to discuss about these articles are discussing about the UPSC. Then regarding UPSC, first thing is the composition. One chairperson, one chairman would be there for UPSC. Then UPSC is composed of one chairman or chairperson, and the second are members. The number of members, how many members would be there in the UPSC? Constitution speaks that the number of members for the UPSC will also be fixed by the President of India from time to time. Then President of India will fix. Then number of members would be fixed by President of India from time to time according to the Constitution. At present, there are 10 members in the UPSC. Then presently we have one chairperson and 10 members in the Union Public Service Commission. Now we can see that is about the composition of the UPSC. And second thing is that, and one more thing regarding the 10 members. Out of the 10 members, half of them should have the experience under the government service for 10 years. Then half of them, then 5 of these 10 members should be from the government service itself. Anybody who served the central government of India for minimum 10 years in any government service, then 5 members should be having 10 years experience in government service. Then composition is that present composition is one chairperson and 10 members. Out of the 10 members, half of them should be from the government service, half of them should be from the people who have experience in the central government service for a minimum term of the 10 years. Now next one, after finishing the composition is the first topic. How many members would be there? One chairperson and such number of members as fixed by President of India from time to time. At present, President has fixed 10 members. Out of that, 5 or the half should be having experience for 10 years or more in any government service. And second one is that what is the term of the UPSC? Then term of chairperson of UPSC, once appointed, how long they will continue in the position of the UPSC chairperson and members, that is also similar to the term of the Election Commission of India, which we have discussed earlier, either 6 years or 65 years of age, whichever comes earlier. Then either 6 years of term or the 65 years of age, whichever comes earlier. That means if a person is appointed when he is 60 years old, he will get only 5 years, not 6 years. If a person is appointed when he is 55 years old, he will completely finish the 5 years term and he will retire at the age of 61. Then either 6 years of age, 6 number of years, or 65 years of age, that is the term of the UPSC chairperson's term, is discussed in Article 316 of the Indian Constitution. 315, we have discussed that 315 discusses about the composition, or they are appointed by the President of India. 315 tells that there would be one chairperson and such number of members fixed by the President of India. They are appointed by the President of India as the members and chairperson of the UPSC or the Union Public Service Commission. Next one, then after finishing the term, the next article, Article 317 of the Indian Constitution, discusses about the removal of the Union Public Service Commission, how the chairperson of the Union Public Service Commission and the members of the Union Public Service Commission, they can be removed. Removal, there is no role for the Parliament in the removal. Removal will be done by the President of India. Then removal, the authority to remove the chairperson and members of the UPSC is the President of India. But President of India will remove after a Supreme Court inquiry finds the person guilty of the offence. Then the removal can be done for misbehavior. The reason for the removal is misbehavior. Then the authority to remove is the President of India, and for removing an inquiry has to be made by the Supreme Court of India. Then Supreme Court can decide which judges will make the inquiry. Imagine that an allegation of corruption comes against any Public Service Commission chairperson, Union Public Service Commission chairperson or members, then President of India will get the complaint. After getting the complaint, President of India will forward the same to the Supreme Court of India and will ask them, please make an inquiry and submit the report to me. Then President of Supreme Court of India, after making an inquiry, if they find the person guilty of the alleged offence, they will submit the application, submit the report to the President of India. When President of India gets the report, President of India can simply remove the person. No role for the Parliament. Removal of the Election Commission is a tough procedure. This is a comparatively non-tough or a easy procedure, the removal of the Union Public Service Commission chairperson and members. Then removal is done by the President of India on the ground of misbehavior after a Supreme Court inquiry finds the person guilty of the alleged offence, that is discussed in Article 317, that is the removal of the members and the chairperson of Union Public Services Commission. Now we are going to discuss about another important provision regarding the UPSC, that is after the retirement, the chairman of UPSC cannot get any further employment under the government of India. That is Article 319 of the Indian Constitution. Article 319 talks about the provision that the chairman of UPSC cannot take any further employment under government of India. No further employment. Once a person is appointed as the chairperson of UPSC, if he retires from the retirement is that either he finishes 6 years or he reaches the 65 years of age, whichever comes earlier, that is the retirement time or the retirement for the UPSC chairperson. Then Article 319 tells that after retirement, he will not be eligible to get any position under government of India or any employment under government of India or the government of any state government. And what is the logic of this? And the logic is that UPSC as we discussed earlier, their main function is the conducting the examinations for the recruitment of the candidates for different high profile central government positions or the central government jobs. Then they have to be completely independent, completely free from any political influence, even if the son of a political leader or the son of an eminent politician comes for the interview of the UPSC civil services examination, he should not get any favor. And even if a person from the poorest of the poor background comes for the interview, he or she should not be discriminated in any manner. Then there should be complete freedom for the chairperson and members of the UPSC from any outside influence. Outsiders should not have anything to show them, because politicians, many officers, many people who are employed under government of India, sitting in high positions, they want to please the politicians. For what reason? For getting any employment after this. Okay, after finishing 6 years term, I want to get any other employment, either to be appointed as the governor of a state or to be appointed as the chairperson of some other commissions. Then if a person desires to get some other positions under the government of India or the government of any state, after retiring from one position, then sitting in that position, he may please the political masters or the political authority or the group people who are affiliated to any political party. Then to save the Union Public Service Commission chairperson and members from any such influence, outside influence by the politicians, the constitution has denied them any further office. Then they can work without having any outside pressure, because outsiders cannot pressurize them. After retirement, no position. Constitution tells that you cannot take any position under government of India. Then he does not need to please any person for getting any position after the retirement. Then for the UPSC chairperson, this is for UPSC chairperson, for the chair of UPSC, and he cannot get any further employment under the government of India. That is, no further employment. Nothing can be received as a employment under government of India after retirement. Now next thing is that for the members of UPSC, then members of UPSC, they have also some restrictions in receiving any further employment under government of India. The members of the UPSC, they can be either appointed as the chairperson of UPSC or the chairperson of any other UPSC. They cannot get any employment. Except chairperson of UPSC. Then except chairperson of UPSC or any state public service commission. Then a member of UPSC, after retirement, he can be appointed only in two government employments. They are chairperson of UPSC, either he can be appointed as chairperson of UPSC or the chairperson of any state public service commission. Now next thing is that chairperson of any state public service commission, then chairperson of a state public service commission, he cannot receive any further office under government of India except as the chairman of any other state public service commission or member or chairman of UPSC. Then if a person is the chairperson of Tamil Nadu State Public Service Commission, after retiring from the position of the chairperson of Tamil Nadu Public Service Commission, he may be appointed as the chairperson of UPSC. He can be appointed as the chairperson of UPSC or the chairperson of any other state public service commission other than Tamil Nadu, or the state public service commission, chairperson of the state public service commission of Kerala, he can be appointed, or he can be appointed as the member of Union Public Service Commission, member of UPSC. Only these three positions are permitted for a person who retired from the position of the chairperson of any state public service commission. Then anybody who got retired from the position of the chairperson of union, chairperson of any state public service commission, he can either be appointed as the chairperson of UPSC or the member of UPSC or as the chairperson of any other state public service commission. Next one, a person who got retired as the member of state public service commission. If one person retired from the position of the member of a state public service commission, he cannot get any further office except as the chairman of that state public service commission or member or chairman of UPSC. Then he can get the position of the chairperson of UPSC, he can get, or that state public service commission or any other state public service commission also, or he can get, along with that, he can get maximum member of UPSC also. Then either he can be appointed as the chairperson of UPSC or member of UPSC or the chairperson of the same state public service commission or any other state public service commission. Then a person got retired as the member of state public service commission. He cannot be appointed as the vice chancellor of any university, or these people cannot be appointed as the vice chancellor or chancellor or governor or any other position under the government of India cannot be given to these people. Who, whether a person got retired as the chairperson of UPSC, he cannot get anything. Then member of UPSC can be appointed either as the chairperson of UPSC or chairperson of any state public service commission. Chairperson of the state public service commission can get the position of either chairperson of UPSC or chairperson of any other state public service commission or the member of UPSC. A member of state public service commission, he can either be appointed as the chairperson of UPSC or the chairperson of the same state public service commission or any other state public service commission or the member of Union Public Service Commission. Then there are restrictions for the people who are appointed either as the chairperson or members of UPSC or the State Public Service Commission from being appointed in any further office after the retirement. These restrictions are discussed in Article 319 of the Indian Constitution. Now we are going to discuss about the functions of the UPSC. Article 320 of the Indian Constitution discusses about the functions of the UPSC. Functions, as all of us know, UPSC has different functions. Main function of the UPSC is conducting the competitive examinations for the selection of the Indian civil service aspirants. They are conducting the examination for Indian civil service, Indian economic service, Indian engineering service, and different services, and different people, different candidates to the group A and group B of the government services, then conducting the competitive examinations. That is, one function is competitive examinations. Second is the recruitment and direct recruitment of into different positions. Then competitive examinations and direct recruitment into different positions is also done by UPSC. These are common functions, as all of us know. These, and UPSC is mainly established for these functions. Now some other functions. Imagine that one government officer or a central government officer has a claim and he puts forward a claim for injury, or he wants to get the pension, he wants to make a claim for the pension. Then claims of the central government officers for injury, pension and other benefits has to be considered by the UPSC. Then UPSC will consider the claims of a central government officer for the following purposes. One is injury, and while he was sitting in the service, he got some injury. Then he wants to get the claim for the injury or the medical claim for the injury. And claims of the central government officers for injury and pension and if they want to get the early retirement and the pension. And the third one is that other benefits or claims of central government officers for injury, pension or any other benefits. This will be considered by the Union Public Service Commission. This is a function of the Union Public Service Commission. Then UPSC would consider the claims of the central government officers for pension, injury and other benefits. And the point is that UPSC is the last authority in this regard. A decision of UPSC on this regarding the pension or injury benefit or the other benefit of a central government employee cannot be questioned in any court of law. Then there is no solution for the UPSC for these things. Then for these matters there is no solution from any court of law. Then there is no solution in the court of law regarding the claims of a central government officer for injury, pension and other benefits cannot be solved from the court of law, and the final solution can be gained from the Union Public Service Commission. Now next one is that if the central government makes any decision related to the recruitment of the candidates for different central government services, Group A and Group B services, without consulting UPSC, that is invalid. Then while central government is making any decision, for example, reforming the exam pattern of the UPSC civil services examination, that is something related to the recruitment of the officers into the central government service. Then government decisions in the recruitment without consulting UPSC is invalid. Then whenever government makes a decision, government makes a decision regarding recruitment, government has to do the consultation with UPSC. Then all government decisions related to the recruitment can be done only in consultation with the Union Public Service Commission. Any government decision without consulting Union Public Service Commission is invalid. Now next point is that these are the basic functions of the UPSC. Now giving any additional function into the UPSC, then recruitment, selection examinations and other matters, consultation in the case of the any new law on the recruitment, and the consideration of the injury benefit, pension benefit and other benefits of the central government employees would be done by the Union Public Service Commission. Now Article 321 discusses about additional functions for the UPSC. Then if an extra function which is not mentioned in the Constitution has to be given to UPSC, then who is the authority to give these functions for the UPSC? Then additional functions of the UPSC can be given by Parliament of India. Then additional functions for Union Public Service Commission would be the authority to give additional functions to the Union Public Service Commission is Parliament of India, and for the state public service commissions it would be given by the state legislative assembly, that we will discuss there. Next one, UPSC suggestions for the appointment. If UPSC makes some suggestions after conducting the examination and they shortlist the people to be appointed in different central government positions or the state government positions also, then UPSC suggestions for the appointment cannot be rejected by any authority in India except the appointment committee in the Union Cabinet. Then UPSC decisions on the appointment can be rejected. Then any decision of the UPSC, then UPSC decisions can be rejected only by one authority in India, that is the appointment committee of the Union Cabinet. Union Cabinet will have a committee on the appointment. Union Cabinet means the senior ministers in the central government. then in the out of the senior ministers in the central government, that is the cabinet, there would be a subcommittee. For the union cabinet, there would be a subcommittee which will take the decisions on the appointment. Then if there is any problem in the selection of the UPSC, then shortlisted names can be rejected only by one authority. Then the authority above UPSC which can reject the UPSC recommendation on the recruitment is appointment committee of union cabinet, or the suggestions on the appointment can be rejected only by the appointment committee of the union cabinet of India. Now we are going to discuss some other matters in which UPSC will not be consulted. We have mentioned that all decisions of the union government relating to recruitment of the candidates for the government services, UPSC has to be consulted. But some provisions related to the recruitment, UPSC will not be consulted. Then what are the provisions in UPSC is not consulted? Then UPSC is not consulted in the following matters related to the recruitment. Then we can see what are these matters. One is reservation. How much percentage reservation has to be given to scheduled caste, scheduled tribes and other backward communities in India, or any other section which is socially, economically and educationally backward? That decision can be taken by the Parliament of India without consulting UPSC. Then UPSC would not be, whatever Parliament makes the system for reservation, UPSC has to follow that. In that matter, UPSC will not be considered or will not be consulted. Then in the matter of reservation, UPSC will not be consulted. Second thing, some constitutional bodies, head of the constitutional bodies, for example, who will be appointed as the chairperson of National Commission for the Scheduled Caste, National Commission for the Scheduled Tribes, then chairman and members of the commission. In the appointment of the chairperson and members of different commissions, in that we have discussed for particular commissions, the appointment body is a group of people including Prime Minister, Home Minister, Speaker of Lok Sabha, and different arrangements are given either by the constitution or by any statute for the appointment of some chairperson and members of different organizations or the different government commissions, simply of commissions. Then chairpersons and members of different commissions also would be appointed by the government of India without consulting the Union Public Services Commission. Next one is that appointment of the officers into Group C and Group D, because UPSC only Group A and Group B comes under the UPSC. Group C and D appointment would be done by other institutions like SSC, Staff Selection Commission, etc. Then appointment of the Group C and Group D officers, Union Public Services Commission would not be consulted. And next one, appointment of a person for temporary time period. For example, somebody is recruited as an ad hoc employee for less than 1 year. That is why most of the ad hoc employees, they have to renew their contract after 1 year. They will be appointed for a term of 1 year. Then any temporary appointment for a period less than 1 year, then temporary appointment for a period less than 1 year also. In that matter also, UPSC is not needed, it is not mandatory to consult with the UPSC, and UPSC will not be consulted. And this is these four are the matters in which UPSC would not be consulted, and although these are related to the recruitment of the candidates for different government services. In the reservation, in the case of reservation, UPSC will not be consulted. In appointment of the chairpersons and members of different commissions also, and Group C and Group D, and the temporary appointment for less than 1 year. And one more thing, appointment of the members into tribunals and the higher diplomatic positions. Tribunals, we have already discussed that appointment of the judges and appointment of some other officers into tribunals, and diplomatic positions, appointment of the Indian ambassador in the US or High Commissioner of India in Sri Lanka. These matters the Union Public Service Commission will not be consulted. Then these 5 matters, appointments into the tribunals and the diplomatic positions of India also, Union Public Services Commission would not be consulted, and UPSC. And finally we have to discuss one more thing related to UPSC, that is report of the UPSC. Every year UPSC has to submit a report. Article 323 of the Indian Constitution. Article 323 discusses about the report of the UPSC. Then every year UPSC has to submit the report to the President of India. Then report would be submitted by the UPSC to the President of India, and President is the authority to receive the report from the Union Public Service Commission. UPSC is known as the watchdog of the merit system in India. The duty of the UPSC is to select meritorious candidates into the different central government services or high profile services like the Indian Administrative Service, Indian Foreign Service, Indian Police Service, Indian Revenue Service, etc. And that is why UPSC is known, because their duty is to protect the merit system in India. That is why UPSC is known as the watchdog. The watchdog will protect the house, then watchdog of merit system in India. Then UPSC is the protector or the watchdog of the merit system in the appointments for the different government positions in India. Then UPSC has a high profile constitutional body. It has one of the crucial functions in the functioning of Indian democracy, that is selecting the candidates for, or the meritorious candidates for different high profile government services. Now we are going to discuss about the articles related to the Union Public Service Commission. We have already mentioned that Union Public Service Commission or UPSC is mentioned under articles starting from 315 to 323 of the Indian Constitution. Now we can see what these articles are discussing about. First one is Article 315 of the Indian Constitution. Then Article 315, it establishes 2 bodies. One is a Union Public Service Commission for the central government employment, selection of the central government employees, and another one is a State Public Service Commission for different states. Then it establishes 2 bodies. One is Union Public Service Commission and the second one is State Public Service Commission. Then these 2 are the constitutional bodies under Article 315 of the Indian Constitution. Next is Article 316 of the Indian Constitution. Article 316 discusses about the appointment and the term of the office members. How many, what is the who is the authority to appoint the chairperson and members, and how much is the term? Both we have discussed. The chairperson and members of the Union Public Service Commission are appointed by the President of India, and their term also we have discussed, that is either 6 years or 65 years of age, whichever comes earlier. Next one is that Article 317 of the Indian Constitution. Article 317 discusses about the removal and suspension of the member of Public Service Commission. Removal and suspension. Removal we have discussed. The President of India will remove after a Supreme Court inquiry and for proved misbehavior. If there is any misbehavior from the chairperson or members of the UPSC, he will be removed by the President and after a Supreme Court inquiry. When the Supreme Court inquiry is going on, he will be suspended again by the President of India until the Supreme Court inquiry report comes to the President. Next one is that Article 318. Article 318 is related, we have not discussed that in the chapter, power to make regulations as to the conditions of service of members and the staff of commission. Then that is the power of the commission to make the regulations. Then regulations can be made for the members of commission, regulations for the members, and there would be some other staffs also. Then these things are related to the, that is a technical article. Then what are the regulations for the members of the commission and the staffs who are working inside the Union Public Service Commission? Next one is that Article 319. Article 319 of the Indian Constitution discusses about the regulation for the chairperson of the UPSC and the members of UPSC, SPSC, everything for taking any employment after retirement. Then Article 319, we have discussed that in detail. Prohibition of the holding office by members of commission after ceasing to be such members. Then employment after retirement. This is about the restrictions on the employment after retirement for the members and chairperson of UPSC and the state public service commissions, that is discussed under Article 319 of the Indian Constitution. Then Article 320 we have discussed in detail, that is the functions of the Union Public Service Commission. Then functions of UPSC are discussed under Article 320 of the Indian Constitution. Next article is Article 321 of the Indian Constitution. Article 321. 321 discusses about the power to extend functions, because already functions are described under Article 320. Now if some extra functions have to be given, who is the authority to give the extra functions? We have discussed that in the additional powers. We can make it as additional powers for the public service commissions. Then in the case of UPSC, additional powers would be given by the Parliament of India. Parliament of India is the authority to give additional functions for UPSC. In the case of State Public Service Commission, additional powers to the State Public Service Commission can be given by State Legislative Assembly. Then in the case of UPSC, it is done by Parliament of India. We have discussed there in the class. And in the case of State Public Service Commission, it is done by State Legislative Assembly of the concerned state. Next article is Article 322 of the Indian Constitution. Article 322 discusses about the expenses of the Union Public Service Commission. Then expenses of the Union Public Service Commission would be charged out of the Consolidated Fund of India. Then in the case of UPSC, it will be taken from Consolidated Fund of India. In the case of the State Public Service Commission, it will be taken from the Consolidated Fund of the state. The next is Article 323, the last article in the part related to Union Public Service Commission, that is Article 323, discusses about the report of the Union Public Service Commission. Then report of the Union Public Service Commission has to be given to President of India. In the case of State Public Service Commission, it has to be given to the Governor of the concerned state. Then report would be submitted to the President of India by Union Public Service Commission. The State Public Service Commission, they would submit the report to the Governor of the concerned state. Next constitutional body we are going to discuss is State Public Service Commission. Then State Public Service Commission, we have already discussed that State Public Service Commission is also a constitutional body under Article 315. The articles starting from 315 of the Indian Constitution to 323 discuss about different provisions related to the Union Public Service Commission as well as State Public Service Commission. Then State Public Service Commission is also a constitutional body established under Article 315. Different provisions related to State Public Service Commissions are also discussed. between articles 315 to 323 of the Indian Constitution. We can see the chairperson and members of the State Public Service Commission. First, we are going to discuss about the appointment of the chairperson and members. Then chairperson and members of the State Public Service Commission are appointed by the governor of the state. Then appointment is done by the governor of the state. In the case of UPSC, that is the President of India. But although appointment is done by the governor of the state, next thing is that removal. And appointment is done by the governor, but removal of a State Public Service Commission chairperson or members can be done only by the President of India. Then removal is tough. Removal can be done by President, but appointment is done by the governor. A body appointed by the governor but removed by the President of India. Then President of India can remove after a Supreme Court inquiry. For this purpose also, Supreme Court inquiry has to be done as similar to the removal of the chairperson and members of the Union Public Service Commission. Then appointment is done by governor, and removal can be done only by the President of India after a Supreme Court inquiry when the removal procedure is going on. After receiving a complaint, the President of India has forwarded that to the Supreme Court of India for making an inquiry. When the Supreme Court inquiry is going on, the person or the chairperson or members can be suspended. Then suspension, when the Supreme Court inquiry is going on, can be done by the governor of the state. Then suspension and appointment is the authorities, the powers of governor, but the final removal can be done only by the President of India. Next one is that what is the term of a State Public Service Commission chairperson and members once appointed? How long they will continue? The term is either 6 years or 62 years of age. In the case of the UPSC chairperson and members, this was 65. Then the difference here is that for the State Public Service Commission members and the chairperson and members, the term is 6 years. This is similar in the case of UPSC and the State Public Service Commission. But 62 years, in the case of UPSC, this was 65. And in the case of State Public Service Commission, it is 62 years of age. Now, number of members. How many members would be there in a State Public Service Commission? That is decided again by the governor of the state. Then number of members, how many number of members would be there? That is also decided by the governor of the concerned state. Then every state may have different number of members in their State Public Service Commission. But one condition is there: half of the members should have experience in working under the state government. Half of the members should be selected from the state government servants or the state government employees who should definitely have the service experience under the concerned state government. Now, next thing is that additional powers. For that we have already discussed. Additional powers for the State Public Service Commission can be given by the State Legislative Assembly. For the Union Public Service Commission, additional powers can be given by the Parliament of India. In the case of State Public Service Commission, additional powers can be given by the State Legislative Assembly. Next body we are going to discuss today is Joint Public Service Commission. Joint Public Service Commission, I am taking the discussion here because it is related to Union Public Service Commission and the State Public Service Commission. Otherwise, it is not a constitutional body. Constitution does not mention about a body named as Joint Public Service Commission. Then it is, although it is not a constitutional body, we are taking the discussion here because it is related to Union Public Service Commission and the State Public Service Commission. Because Constitution does not mention anywhere about a body called as Joint Public Service Commission. Joint Public Service Commission means that if two states together wants to have a single public service commission for both of them, then government can set up a commission for them both together instead of having one each. For example, if two states, Assam and Nagaland, if they want to have a public service commission, want to have only one public service commission for conducting different competitive examinations for both of them, that can be done. That is possible in India. We have one existing joint public service commission also, because Punjab and Haryana, the states of Punjab and Haryana, when they got divided, because earlier Haryana was a part of Punjab state, then when they got divided, they did not divide their state public service commission. They made a joint public service commission. They wanted a joint public service commission for both Haryana and Punjab. That is the real life example or the existing example for a joint public service commission. Then how Joint Public Service Commission can be constituted? It is a statutory body. Statutory body means that when more than one state demands to the central government of India that we want a joint public service commission, then the Parliament of India can set up a joint public service commission for more than one states in India through a special legislation in that regard. Then Punjab Haryana Joint Public Service Commission was set up by a parliamentary act when both the states demanded so to the Parliament of India. Then basically Joint Public Service Commission is a statutory body established by the Parliament of India when more than one states demand to establish a joint public service commission for them. Now we can see the different provisions related to the Joint Public Service Commission. We told that it is not a constitutional body, it is a statutory body, and the present example is Punjab and Haryana. Now we can see what is the term for the chairperson and members of a Joint Public Service Commission. That is also similar to the State Public Service Commission. 6 years or 62 years of age is the term for the members and chairperson of the Joint Public Service Commission if it is established. Another one, now in the case of State Public Service Commission, we mentioned that members and chairperson would be appointed by the governor. In the case of Union Public Service Commission also we mentioned that members and chairpersons would be appointed by the President of India. Then in the case of State Public Service Commission, appointing authority is the governor. In the state of Union Public Service Commission, the appointing authority is the President. Now in the case of Joint Public Service Commission, appointment of the members and the chairperson would again be done by the President. Otherwise it will be a dispute whether which governor will appoint. Two states will have two governors. Then appointment will be done by the President of India. Then removal in the case of State Public Service Commission also removal is done by the President. Then removal will also be done by the President of India. Then suspension in the case of the State Public Service Commission, we mentioned when the inquiry is going on in the Supreme Court, President will remove after a Supreme Court inquiry. When the inquiry is going on in the Supreme Court, in the case of State Public Service Commission, suspension is done by governor, but in the case of Joint Public Service Commission, suspension will also be done by the President of India. Then when the inquiry is going on, President will suspend the joint chairperson and members of the Joint Public Service Commission. Now next issue is that report. In the case of Union Public Service Commission, we mentioned under Article 323, UPSC will submit the report to the President of India. The State Public Service Commission will submit the report to the State Governor. Then in the case of JPSC, Joint Public Service Commission, to whom they will submit the report. Then they will prepare two reports. One report will be submitted to the governor of one state and another report would be submitted to the governor of the another state. Then Joint Public Service Commission of Punjab and Haryana, they will prepare two reports. One will be given to the governor of Punjab and another one would be submitted to the governor of Haryana. Then the report of the Joint Public Service Commission would be submitted to both the states or the governors of the two states. Next constitutional body we are discussing today is the Finance Commission of India. Finance Commission of India is also a constitutional body functioning under Article 280 of the Indian Constitution. Then Finance Commission is mentioned in Article 280 of the Indian Constitution, speaks about a constitutional body named as Finance Commission. What is Finance Commission? Finance Commission means that because different types of the taxes, revenues and resources are there for the Union Government of India. Out of that, some taxes the central government shares with the state government. Some resources are also shared between the center and the states. Then Finance Commission is the constitutional body which recommends to the government how much money, how much resources out of the central resources have to be shared between the states, or how much money has to be given by the central government from its different sources of income to the different state governments. This is the main duty, that is distribution of the resources of the center between the center and the states is the main function of the Finance Commission of India. Then Finance Commission, as I discussed, the first point is that it is discussed under Article 280 of the Indian Constitution. Then second and the most important point is that Finance Commission is a quasi-judicial body. Quasi-judicial means that half judicial power. It is not a full judicial because it is half financial body and another half it is a judicial body. It makes a judgment how much money has to be shared by the center with the states. One thing. Another one, it can request from different departments related to finance to submit some documents in their office. If they want to verify how much money earned by the central government of India through GST in the last 1 year, they can ask the finance department or the tax authorities to bring adequate documents into the office of the Finance Commission. Then demanding any government body to produce any document in front of one body is a judicial power. Then that is why Finance Commission is known as the quasi-judicial body. Next thing is that related to the composition of Finance Commission, how many members would be there and chairperson. Finance Commission will have one chairperson and 4 members. One is chair and the second part of the Finance Commission is 4 members. Then 4 members. Finance Commission is a body composed of 1 chairperson and 4 members. What is the term? Next thing, once they are appointed after finishing the composition, this chairperson and 4 members, for how many years they are appointed? The term of the Finance Commission is 5 years. Once appointed, they will continue for 5 years. Then every 5 years, the President of India will compose or will constitute one Finance Commission for India for the next 5 years. Then the Finance Commission of India is appointed for 5 years. Every 5 years, the President of India will constitute one Finance Commission for India as per Article 280 of the Indian Constitution. Now, what are the qualifications of these people when they are elected? What qualifications these 4 members and the chairperson should have? And what is the manner of selection? How they will be selected? And what is the method of selection, how they will be selected? These things are not mentioned clearly in the Constitution. Constitution tells that Parliament of India can decide, and the qualifications of the members and the chairpersons and the method of selection would be decided by Parliament of India. That is Article 280 mentions about the qualifications and the selection of the members. Then accordingly, now if the Constitution mentions that, tells that Parliament will decide the qualifications and method of selection, then Parliament can decide it through a legislation, by making a new act. Then for that purpose, for deciding the qualifications and the manner of selection of the members and the chairperson of Finance Commission, Parliament of India made an act in 1951, that is Finance Commission Miscellaneous Provisions Act 1951. Then Finance Commission Miscellaneous Provisions Act 1951 was passed by the Parliament of India to decide the qualifications and the method of selection of the chairperson and members of the Finance Commission of India. This act tells that chairman should be a person having experience in public affairs. Then the qualification of the chairman is he should be a person having experience in public affairs, in any public affair and some public service or any others. Anyway, the person should have experience in dealing with many affairs in the public sphere of India, that is the government sphere. Then having experience with the government, a person or maybe an economist or a finance expert having experience with the public matters, that is the government affairs in India. That is what the Finance Commission Miscellaneous Provisions Act 1951 mentions about the qualifications of the chairperson. Now we are going to discuss the next part of the Finance Commission Miscellaneous Provisions Act 1951. First provision we discussed the qualification of the chairperson. The qualifications of the chairperson is that he should be a person having experience in public affairs. Now the second part of the Finance Commission Miscellaneous Provision is that qualification of members. Then what are the qualifications of 4 members? We already discussed that the composition of the Finance Commission is 1 chairperson and 4 members. Then 4 members, the Finance Commission Miscellaneous Provisions Act 1951 mentions 4 different qualifications for the members. Then member 1, he should be a judge of High Court or qualified to be so. Then he should be a person who is either a retired judge of the High Court or the person should be qualified to be a judge of High Court. What are the qualifications of the judge of High Court? We have discussed earlier. He should be a citizen of India, having 10 years experience as a advocate of the High Court or above, otherwise having 10 years experience as a judge in any lower than the High Courts in India. Then this is a judge of High Court or qualified to be so. 1 person out of the 4, member 1 should be either a judge of High Court or a person who is qualified to be a judge of High Court. Then second person is a person having special knowledge in finance. Finance means that finance is mostly related to the accounts or the accounts of Government of India. A person who has experience of finance or the accounts of Government of India. Finance is that it is a part of economics, that is banking and money transactions and accounting. These comes in the finance section of the finance section of the economics. Then second member should have special knowledge in finance or an expert in finance or the accounts of Government of India. Then we can see what is the qualification of the third person. The third member should have knowledge in economics, the wide economics. An economist we can call a person who has knowledge in economics, special knowledge in economics should be the third person. Otherwise an economist should be the third person. Second person should be an expert in finance and accounts. Next one, the fourth and the last member should be, and the qualification for the fourth member, he should have experience in financial matters and the financial administration. Then here he is an expert in finance and accounts. Here a person having experience in financial matters and especially in the financial administration, and most probably the people who are coming from the Indian Economic Service will have the experience of the financial administration. Then that fourth member's qualification is that he should have experience in the financial matters and the financial administration. Here he should have knowledge of finance, although he does not have the experience. If a person has knowledge of finance and accounts of India, he will be considered as the second person. Then four members should be coming from four different levels of qualifications. First member should be a judge of High Court or a person qualified to be a judge of High Court. Second member should be a person having knowledge in finance or accounts of Government of India, and the third member should be a person having knowledge of economics, and the fourth person a person having experience, not only knowledge, experience in financial matters and in the financial administration of India. The next discussion is about functions of the Finance Commission. Finance Commission, what are their functions under Article 280 of the Indian Constitution? What functions will be done? I have given one introduction in the beginning that their main function is distribution of the resources between the center and different state governments. That is the main function of the Finance Commission. Then first function is that distribution, whatever things they will distribute. One is net proceeds of the tax. Net proceeds of the tax means that, and total amount of tax is different, and net proceeds of the tax is also different. Imagine Central Government of India, this is an imaginary estimate. Central Government of India is getting total tax of 100 crore. Then this is not the real, and 100 crore rupees total tax is earned by the Central Government of India. Then out of this 100 crore, there would be some expenditure for collecting the tax. Some tax collection officers have to be appointed, they have to be paid the salary, and some offices have to be established for tax collection. Some technology has to be developed for the tax collection, and different expenditures are there for the tax collection. Out of this, 10 crore rupees was the expenditure for collecting this 100 crore. Then after reducing the expenditure for collection, what net amount comes up, that is 90 crore rupees. That is the net proceeds of the tax. Then the tax, totally collected tax, the amount totally collected as a tax, after reducing the amount for the collection, or after reducing the expenditure for collecting the tax, is known as the net proceeds of the tax. Then out of these net proceeds of the tax, how it will be distributed to the states, then how much will be given to the states out of the net proceeds of the tax, and distribution to states out of the net proceeds of the tax is decided by the Finance Commission of India. Next one, other than tax also, government will have different resources. Sometimes government will be getting the profit from a government company which is established in one state. Oil India government company established in Assam. If the government is getting some profit out of that, then that is also a government, that out of that also government will share something. The tea gardens in Assam, if the government is getting some amount, some profit out of that, that will also be shared with the state. Then distribution of other resources, then not only net proceeds of the tax and other resources also. Out of the other resources, how much money will be shared with the state governments, that will also be decided by the Finance Commission of India. Next one is that there was a temporary function for the Finance Commission between the years 1950 to 1960, for 10 years after commencement of the Constitution, because the Constitution of India started functioning from 26 January 1950. From that time up to 1960, there was some temporary function for the Finance Commission. We can see what is that. Some states, Assam, Bihar, Odisha and West Bengal. Then Assam, that temporary function was for these states, Assam, Bihar, Odisha and West Bengal. These four states, after the partition of India, they had a financial problem because these four states are rich in producing the jute. They are the largest producers of the jute. Before partition, Bangladesh was also a part of India, or the East Bengal, Bangladesh was also a part of India. Then before the partition, most of the jute mills, or the mills which are refining the jute, they were in the Bangladesh or in the Eastern Bengal, and most of the jute cultivation was in the western part of Bengal, or the western part of Indian part, in the present day Indian states of Assam, Bihar, Odisha and West Bengal. And Assam, Bihar, Odisha and West Bengal, they have large number of jute cultivation, but they don't have the jute mills for making the jute fabrics out of the jute. Then what they did, initially they were exporting the jute into the present day Bangladesh. That time it was a part of Pakistan. Then Eastern Bengal, or the present day Bangladesh, they were exporting the jute into those countries. Then export of the jute was one of the most important source of income. Then while exporting, there will be customs duty, then export duty will be their export tax, that is called as customs duty, will be earned by the central government of India. Then by 1960, why we stopped it, we planned to establish our own jute factories in India. Then earlier, jute was produced in India and it was exported, the raw jute was exported to Bangladesh. Then out of that money, some revenue was earned by the central government of India. Then for 10 years, between 1950 and 1960, Finance Commission has to recommend how much money out of the total income earned by the central government from the export of jute from these states would be shared between the center and these states. Then till 1960, Finance Commission suggested the grants for Assam, Bihar, Odisha and West Bengal from the net proceeds of the jute exports into Bangladesh or any other country, from the net proceeds of the jute exports. And another important feature related to the Finance Commission is that recommendations of the Finance Commission is only advisory. Then it has only the value of an advice given by the Finance Commission to the central government of India. It is not binding on the central government, or it is not mandatory for the central government to follow the advices of the Finance Commission of India. And by this we are finishing the constitutional bodies. We have discussed almost all important constitutional bodies in India, and we are also finishing the Indian polity. Then I advise all the students, we have finished one subject and go through the subject thoroughly, and after today we will take 2-3 complete comprehensive test of 100 questions on the Indian polity, and attend the question papers also and verify whatever you have studied. And this is the last class of the Indian polity, and from next day we will be starting another subject. Thank you for watching an Academy of Civil Services online coaching for different civil services examinations. Thank you once again.